It's over 140 pages long. It's Jack Smith's Volume 1 of the Special Counsel final report about the D.C. election interference case. And finally, after an elaborate game of red light, green light, it's finally out. We have our hands on it. I give a summary of it and the most important aspects of it from a trial lawyer perspective, and I do it on Popok Live. Take a listen. Let me talk about, while I've got a minute, let me talk about Volume 1, right? Jack Smith, so smart, split it into 2 volumes. We were debating whether he'd do 1 volume or 2, but thank God it was 2 volumes because it limited the damage of Judge Cannon. Volume 1 is out. It's 130 pages. I read them all. But there's some takeaways that I can summarize for you right now. There's nothing really glaringly different than what was in the original superseding indictment, the amended indictment that came out, or we reported on it in detail about 3 or 4 months ago. Judge Cannon in the D.C. election interference case required that the government supply a reason why all of the acts and actions of Donald Trump in the D.C. election interference case were not barred by the immunity decision by the United States Supreme Court. So they did 100 pages with an appendix of why so most of it is in there, right? Let me give you some initial reaction to Volume 1. While there's mention of the co-conspirators, and we know who they are, Boris Epshteyn, Rudy Giuliani, it was Jeff Clark at one time, Sidney Powell, and the rest, they're not really, Jeff Clark, they're not really emphasized in the report. That's not surprising. They're not going to spend time or abuse the system to use a final report to go after unindicted co-conspirators and lay out a better case against them. If they wanted to indict them, they would have indicted them. Those people are going to get a hard pass because of the fact that they were co-conspirators with a guy who got elected president. So there's not a lot of Giuliani, Bannon, Clark, sort of attacks. That's one. So if you're waiting on that, it's not in there. Secondly, he explains why, because we were all wondering why. Jack Smith explains why he didn't bring an incitement to riot charge against Donald Trump, even though he blames the Jan 6th events and the riot on Donald Trump. And he said it's basically because under the federal guidelines for prosecution, under his prosecutorial discretion, he did not feel at the end of the day he had enough evidence to satisfy beyond a reasonable doubt on that point, that there were some First Amendment arguments that could be raised, but more importantly, that there was enough debatable evidence about whether Donald Trump intended the riot. We know he caused the riot. We know he fomented the discontent. We know he wound up the Jan 6 crowd, pulled down the magnetometers, let an armed crowd frothing at the mouth be pointed in the direction of the Capitol and said, I'll leading from behind, I'll meet you there. And then they all got all crazed and started bashing police. One of the commentaries in the report about the attacks on law enforcement, 140 law enforcement injured. 2 took their own life because of what they saw that day. 1 died of a heart attack, but clearly from the attack. Others died. 1 was crushed. One of the MAGA had a heart attack. I mean, the events were so terrible. This medieval battle at the Western Terrace, you would have thought you were watching Game of Thrones or something, or some Civil War battle. Jack Smith posits, what do you think would have happened if these people had successfully gotten through the Speaker's Bureau and into the chamber while elected officials and their staff were still there? I mean, if they were braining and trying to kill and maim law enforcement, what chance do you think Nancy Pelosi or Mike Pence or any of the elected officials, including the ones that let Donald Trump off the hook, what chance do you think they would have had as they were belly crawling through the Capitol? 0. So that's another great observation by Jack Smith. But the lead headline, I think, that is out there, and I agree with, as being, the number one takeaway, is that Jack Smith is telling the American people, I had more than enough evidence to convict Donald Trump of all the conspiracies around election interference, all of them, by beyond a reasonable doubt, the highest standard we recognize in the law. I could have gotten a conviction. I stand behind my prosecution. My team stands behind my prosecution. I don't care what they were saying. We were apolitical. I'm a career prosecutor. I have a career that's unblemished in not participating in any kind of partisan attacks. I would never do that. My team did not do that. We followed the facts. We followed the law. We would have won the case, except for the strange occurrence of the fact that Donald Trump won election again. And we had to dismiss the case under the Office of Legal Counsel, which is sort of the internal court system for the Department of Justice under their guidance. He also said that going after Donald Trump presented its own unique special set of problems. It's a slippery legal AFer. I'll leave it at that. He, between his constant delays, his motion practice, the 11th Circuit, coming back and forth, up and down from appellate courts, his late filing on purpose to waste the clock, to take air out of the ball, if you will, made him a very difficult criminal defendant to go after, unlike any the Department of Justice had ever seen. Remember, while they're doing this, the Department of Justice main justice in Washington is trying to prosecute 2,000 people that followed the clarion call of Donald Trump, right? And so, Jax, let me just give you some of the other observations and notes that I took from my first pass. And I'll do other hot takes because there's so many great nuggets in there, but I don't want it to be lost in sort of a kind of a summary fashion. I'll do individual hot takes on the Legal AF YouTube channel about certain aspects that I don't want you to lose sight of. But let me give you the headlines here. He would have obtained a conviction. He had enough admissible evidence to do so. They were nonpartisan in their approach, and that Merrick Garland never interfered. Joe Biden never interfered. He never had communications or contacts coordinated with anybody, which is what we knew, but we wanted him to say it, and he said it in the report. He holds Donald Trump completely responsible, criminally responsible for Jan 6th. That's why he used the conspiracy charges against him. He did not bring the incitement charge that we all wanted, or the sort of direct insurrectionist charge, because of the intent issue, which is a critical component of that statute. Because he's not quite sure from the evidence whether Donald Trump, even in his wildest imagination, thought he was actually going to get these people to attack the cradle of our democracy, the seat of our democracy. And so that's the only reason he didn't bring that. But even if he had brought it, so what? I mean, the fact that he had to dismiss the case later on really doesn't matter. He said he holds Donald Trump criminally responsible for the death and mayhem associated with law enforcement and the over 140 people there. And then to answer a question that's come up since the volume has come out, which I think is interesting. Sort of a thought experiment, though, is that could Donald Trump be retried or tried for any of these matters, given the way the case was dismissed? I mean, the statute of limitations for the crimes they haven't run yet. I mean, they run out in 2026 and 2027, but there is an argument that the whole clock, the statute of limitations clock, is stopped, is put in suspended animation while Donald Trump is president and doesn't restart again until he's out. And we'd have to have litigation over that. Of course, you'd have to get a new prosecutor in 4 years from now for them to argue some sort of relationship back or some other way to restart the clock. He may not be completely out of the woods yet, because everybody, even his own lawyers, acknowledge that whatever immunity he has is a temporary immunity that evaporates, boom, the moment 1201 in 2029. Which sounds like very, very far away, but I assure you it's not. Welcome back. That's a new show I'm doing, a new podcast on Tuesday nights at 8 p.m. Eastern Time, only on the Midas Touch Network. We've got a great audience. We're getting up to 20,000 people to watch the live recording, and we're doing about 3 to 4, almost 500,000 people by the time that week is over. It's a new pro-democracy community. It's beautiful. I'm glad you're there. And it's far-ranging. I do lots of topics at the intersection of law and politics, lots of urgent ones, Tuesday nights, 8 p.m. Eastern Time on Midas Touch Popok Live. So until my next contribution, by the way, you're already here, hit the blue subscribe button and help us continue to grow this pro-democracy channel, Legal AF. We're going to hit 500,000 with your help in the next month or so of subscribers. They're all free. I really appreciate that. We're only 4 months old, but with your help, that's going to be that intersection of law and politics. That's going to be the hottest of corners once January 20th and the inauguration rolls around. So until my next reporting on all things Legal AF, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.